switch over to your current job?
It's been a while now. It's been like, gosh, time flies, but it's been 7 or 8 years now.
Okay. During the contract with America, you were a Senate staffer then, right?
I was.
Yeah.
I was.
And were you the counsel to
Yeah.
the committee? Okay, that's what I thought.
Yeah, that was Bill Roth
Uh-huh.
at the time, and
Right.
later Fred Thompson.
Right.
And we had unanimous votes out of our committee.
Yeah, I remember. That was the closest, especially once for those last second changes to S 1041, whatever.
Thanks for having us. I'm Mr. Chairman Paul Noe, American Falls. It's Tom. Thanks, Tom. Thank you.
Tom, Jeff Clark from Kirkland Ellis. Good to meet you.
Well, it's nice to know.
Thank
I'm
you.
Bill Busby, Georgetown Law School. Nice to meet you. Thanks for having us.
Thank you. Jeff Clark.
We're all set, yes. Hi, Bill Busby.
Good to meet you. Yeah, thanks.
So are you doing mostly appellate litigation?
Yeah, in fact,
Mostly regulatory or of all sorts?
of all sorts. Tomorrow, actually, I argued my 7th Deepwater Horizon appeal in the 5th Circuit.
Oh, is that right?
That's what this is.
Did you
actually.
argue the one that got the Willett ruling?
This one.
The one that found that the issue the state.
Oh, yes. Yeah, I did. I won. That's my case. That's my preemption case. Yeah.
I thought the other side did a good job in the cert petition. I don't know if you thought of it, but I thought they did a very good job trying to. I mean, they didn't get the grant,
Right.
but did a very good job in like explaining the distinctions. In some sense, it was for a solo practitioner. I thought he did a really good job.
I was a little surprised they didn't try to bring in anybody,
Right, maybe
So-
it would have added credibility. But I thought on merits of what he did, I thought it was an effective explanation.
It was definitely the best brief that he filed. Yeah. Did you look at the lower court briefs at all?
I just glanced at that.
Okay.
But
Because his was okay, but there was another collection of parishes, maybe 3 parishes. He had maybe about 10, and there was a collection of 3. That brief was totally incoherent.
Right.
So at least was the one who took the cert petition.
yeah. Well, I'd say this: the Pollution Act's preemption provisions, co-author environmental law casebook.
Right.
And so, if you actually look at the history of the Oil Pollution Act, how it's worked, and the original understanding, and then what courts have done, there's a good deal of confusion, which I'm sure is something you're happy to work with.
Well, but I didn't argue that it was OPA preempted. I argued that it was Clean Water Act preempted, right? So,
Right.
I mean, yeah. So no,
you did like a conflicts of law case.
I
right?
sat down with all the statutes and I kind of like, maneuvered them around and I created a theory. Yeah. No, I'm not sure actually the client fully appreciates like how big a victory that was. Because otherwise they'd have been exposed to billions of dollars in punitive damages from the states.
Yeah.
So,
Yep.
but this, you also probably saw that my Clean Water Act, both en banc petition and first the appeal, then the en banc petition, then the cert petition failed. We got 6 votes from
which case is this now?
This is the one about Clean Water Act penalties, what the amount would be, whether we were liable for them or not. So
I had not followed that. I should look at that. So.
yeah, so we
But I hope
lost
that
in
at
the.
least you were paid through it.
I was.
There we go.
Yeah. That's not been an issue. It's amazing actually how much work that thing generates. People always keep coming to me and it's like, well, that's surely settled. Like I keep reading it, things have settled.
Yeah.
Wow, like I have a list of 20 individual settlement appeals between now and next 2 quarters.
Huh.
So
Was like, do you know Makram Jobber? Was it Hunt and Williams? He's done a lot of the new source review litigation and
name sounds familiar, but no, I don't know him.
But anyway, he says he's made a career out of the 4 lines of what counts as modify under the Clean Air Act. And so, the world of regulation. Some of these things that are the gifts that keep on giving.
Yeah. No, at least I've gotten to have, some broader stuff than that. Although there was a time when I thought, I was like the world's leading expert on Clean Air Act Section 209 and 177 about preemption and all the California stuff. Yeah. Yeah, it was a very sad day actually when I was instructed to call the Associate Attorney General to settle that stuff, and then we had to pull down our appeal in the Second Circuit. We're going to win that case.
Which case was that?
This is a case where we appealed from our loss in the trial court in Vermont. About whether the Vermont, vehicle mandate was preempted or not.
Massachusetts and standing doctrine where it was left. We all kind of agreed. The big question is what power does Congress have to shape standing analysis, and that's kind of how the Supreme Court granted cert and tried to cue that up.
Oh, interesting.
But I didn't look at. I haven't read the argument yet. It was actually a pretty bad vehicle for that. Like in these cases, they granted cert strategically, but I'm not sure the case is.
We'll let them do what they want to do with it.
Yeah, I just don't know if it presents a kind of clean.
No, I haven't been following that. I should look at that. It's called Spokeo, Spokeo.
I think so, yeah. I mean, I've just looked at the descriptions, but I know some of my students are very excited by it. They're like, oh, it's on. What year did you graduate from Georgetown?
95. Yeah, so it's 20 years. I missed a little reunion that my class had at Professor Eskridge's house on Capitol Hill.
Too bad. Did you have him for?
Yeah. He was.
He's a dynamo.
Yeah, he is. We had him for civil procedure in first year, and then I took his statutory interpretation class. Yeah.
He's one of the fastest talking people.
He is. Yeah.
I was once at a conference, and I don't know if you know Elizabeth Garrett, who's another statutory interpreter. She's like a vice provost now at USC, but a productive scholar on statutory issues. And they were sitting at a table in New Orleans, maybe because they were drinking coffee and beignets. The two of them were going, and I don't think I've ever heard two people speak so fast.
Especially since Eskridge is a Southerner, right? Usually,
He gets going.
Yeah. No, he was. He's one of my favorite law professors ever.
Yeah. I often don't agree with where he comes out on lots of things, but he's incredibly perceptive.
Yeah.
Statement.
Total.
Right. Yeah.
Okay, I'll let them know. I'll try to get as quick as I can.
I just want to get it going. Okay. The Subcommittee on Regulatory Reform, Commercial and Antitrust Law will come to order. My colleagues are on their way, but I usually give at least 5 minutes. We've given 7, so we'll get started. I know your schedules are as hectic as ours. Without objection, the chair is authorized to declare recess of the committee at any time. We welcome everyone to today's hearing on H.R. 3438, the Require Evaluation Before Implementing Executive Wish List Acts of 2015, and H.R. 2631, the Regulatory Predictability for Business Growth Act of 2015. And I now recognize myself for an opening statement. Today, this subcommittee continues its overall regulatory reform agenda by examining the targeted reforms to the U.S. regulatory process contained in two straightforward bills. I'm honored that we can take a good look at H.R. 2631, the Regulatory Predictability for Business Growth Act, a bill offered by my colleague, Congressman Steve Russell of Oklahoma. H.R. 2631 addresses a recent Supreme Court decision that upended the process by which agencies can change its own interpretive rules. How to address this change is an important question for us to consider today. Today, this subcommittee will also examine my bill, the Review Act. Over the last decade, our nation has faced a costly and unprecedented regulatory onslaught. During this period, the size and scope of federal regulation has ballooned to epic proportions. Long-standing executive branch policies have mandated additional scrutiny for, and I quote, significant regulatory action, end quote, i.e. those rules with an annual effect on the economy of $100 million or more. But regulatory hubris has flown past these common sense concerns as agencies more frequently propose mega rules with annual cost in excess of $1 billion. But as these monstrous regulations become more frequent, an average of 3 per year during the Obama administration and 6 in 2014 alone, it almost seems that nothing can curtail these potential to damage our economy. This bill is one more step in this subcommittee's continuing effort to put forth common sense regulatory reform measures for the benefit of American workers. The Review Act presents a simple premise that massive billion-dollar regulations should face full and thorough review by the courts before they become effective and force compliance costs on businesses across the country. It achieves this goal through a simple and straightforward mechanism, a mandatory stay of any billion-dollar rule if it is challenged in court within 60 days of its promulgation. Some observers might insist that the reforms in this bill are unnecessary. But just this summer, in the Supreme Court's decision in Michigan versus EPA, we saw firsthand the irreparable harm can occur as a result of expansive, costly, and poorly crafted regulation. In this case, the court found that the EPA has promulgated its utility MACT rule through a faulty process and on legally infirm grounds because it chose not to consider cost when promulgating the rule. In this case, the costs of the rule were estimated by the EPA itself as $9.6 billion per year. In return, the EPA's best estimate of potential benefits were in the range of a mere $4 to $6 million annually. As Justice Antonin Scalia wrote in his opinion for the court, and I quote, "One would not say that it is even rational, never mind appropriate, to impose billions of dollars in economic cost in return for a few dollars in health or environmental benefits. Unfortunately for workers, homeowners, and taxpayers across the country, the utility MACT rule remained in effect as litigation took years to work itself to a final decision at the Supreme Court. Over this time, electricity providers were forced to close power plants as they faced uncertain compliance burdens. Jobs were lost, and electricity costs to consumers rose as a result. Until recently, regulations with billion-dollar annual price tags were a rare occurrence. Since 2006, however, we have seen 26 in total. The Review Act is a step in the right direction to address this growing concern. It also provides a bit of certainty to the American people that massive billion-dollar regulations must pass legal muster before their costs are passed on. I thank the chairman for joining me on this bill, and I look forward to hearing from today's esteemed panel. The chair now recognizes the ranking member of the Subcommittee on Regulatory Reform, Commercial and Antitrust Law, Mr. Johnson of Georgia, for his opening statement.
Thank you, Mr. Chairman. Today's hearing provides this subcommittee with an important opportunity to consider two regulatory reform proposals that would affect divergent aspects of the rulemaking system. The first of these proposals is H.R. 2631, the Regulatory Predictability for Business Growth Act of 2015, which would require agencies to undertake notice and comment under Section 553, the Administrative Procedures Act, prior to revising interpretive rules that are older than 1 year. An interpretive rule is any non-legislative rule issued by an agency to clarify its views on a subject matter. These rules are usually issued in direct response to requests by regulated firms that want more clarity and transparency in a subject area. Because the rule has no binding legal effect, the parties are not bound by an agency's expression of its current rules. Simply put, H.R. 2631 would impose immense procedural and analytical burdens on agencies seeking to provide regulatory clarity through interpretive rules. Excuse me. Not only would this requirement severely burden agencies' existing practice of issuing timely interpretive rules, but it would also wreak havoc on the entire rulemaking system. As Donald Elliott, a professor of law at Yale Law School, noted in 1992, quote, imposing a notice and comment requirement on non-legislative rules would literally grind the modern administrative process to a halt, end quote. In an amicus brief filed in Perez versus Mortgage Bankers, where the Supreme Court unanimously rejected a judicial doctrine requiring notice and comment for revisions to longstanding interpretive rules, a group of leading administrative law experts similarly argued that this requirement would be, quote, burdensome, costly, and time-consuming for agencies, end quote. The second regulatory reform proposal before us today is H.R. 3438, the Require Evaluation Before Implementing Executive Wish Lists Act of 2015, or otherwise known as the Review Act, which would automatically stay high-impact rules that a party challenges within 60 days of an agency's adoption of the rule. Under current law, both courts and the agency issuing a rule may stay the effective date of a rule. While agencies have broad discretion in postponing the effective date of a rule, a court considers several factors in deciding whether to stay a rule, including whether the party is likely to succeed on the merits. Unlike current law, the Review Act would require that agencies automatically delay the effective date for rules exceeding $1 billion in costs, regardless of whether the party challenging the rule has any likelihood of success on the merits, is actually harmed by the rule, or whether staying the rule would be contrary to the public interest. This guarantees that virtually every regulated firm would challenge high-impact rules through frivolous litigation, creating further delays for these rules, which in many cases have already taken years to promulgate. But the bill wouldn't just apply to these rules. Rather, it would likely apply to transfer rules, which involve the transfer of funds for budgetary programs as authorized by Congress, such as transfer rules involving the Medicare program or the federal Pell Grant program. In closing, I'd like to, I look forward to our esteemed panel's testimony today, and I'll yield back.
Thank you. The chair now recognizes the chairman of the full Judiciary Committee, Mr. Bob Goodlatte of Virginia, for his opening statement.
Thank you, Mr. Chairman. Today's hearing continues the Judiciary Committee's efforts to deliver urgently needed reforms of Washington's regulatory system, a system that virtually every day places new obstacles in the path of American jobs and economic growth. We consider today two bills, Subcommittee Chairman Marino's Review Act and Representative Russell's Regulatory Predictability for Business Growth Act. These are new bills developed in response to Supreme Court decisions issued during the Court's 2014 term. The Review Act contains a simple common sense reform responding to a problem highlighted by the court's decision in the case of Michigan versus EPA. The problem is that too often new regulations that impose enormous costs on our society are successfully challenged in court but are not stayed while litigation is pending. Then these regulations are ultimately overturned, but compliance with them has been required while litigation is pending. There can be no question that large amounts of precious resources have been wasted, resources that could have been spent creating jobs, investing in development, and growing America's economy for the benefit of all. The Review Act solves this problem with a simple bright-line test that says if a new regulation imposes $1 billion or more in annual costs, it will not go into effect until after litigation challenging it is resolved. Of course, if the regulation is not challenged, it may go into effect as normal. This is a balanced approach, and it provides a healthy incentive for agencies to promulgate effective but lower-cost regulations that are more legally sound to begin with. The other bill we are examining, the Regulatory Predictability for Business Growth Act, responds to the case of Perez versus Mortgage Bankers Association. The bill would make sure that, notwithstanding the court's decision finding a current gap in the provisions of the Administrative Procedures Act, agencies will provide notice to the public and an opportunity for comment before they change long-standing interpretive regulations. This is only fair. Job creators must live day to day with the interpretations agencies espouse, and the broader public relies on agencies' good faith adherence to sound and settled interpretations of law. Both deserve notice and a chance to comment on changes in interpretive rules before those changes are made. These are simple but powerful reforms that will help to improve Americans' daily lives. I urge my colleagues to consider well and support these important pieces of legislation. I look forward to hearing the testimony of our witnesses today and yield back. Thank you, Mr. Chairman.
Thank you, Chairman. Mr. Conyers, the ranking member of the full Judiciary Committee, will be on his way shortly, and I'm going to reserve the time for his opening statement for when he gets here. And without objection, other members' opening statements will be made part of the record. And I will begin by swearing in our witnesses before introducing them. If you would please stand and raise your right hand. Do you swear that the testimony you're about to give is the truth before this committee, the whole truth, and nothing but the truth, so help you God? Let the record reflect that all the witnesses responded in the affirmative. Please be seated. We have a distinguished panel with us today, and I want to thank the members for being here. Seated to my left, the first gentleman, Mr. Brady, is the president and founder of Brady Homes, Illinois, and the second vice chairman of the National Association of Home Builders. He is a second-generation home builder. Brady Home, Illinois is a small, single-family building and development company that, since its founding by his father, William Brady Sr., in 1962, has become one of the largest home building firms in central Illinois. Mr. Brady has served on the NAHB Board of Directors for more than 10 years and has also held seats on several committees and task forces, including the NAHB Federal Government Affairs Committee and the Budget and Finance Committee. Mr. Brady has been a trustee and chairman of BuildPAC, NAHB's Political Action Committee. Outside of NAHB, Mr. Brady has worked on many boards and commissions, including serving on the board of directors of the Federal Home Loan Bank of Chicago and the Jack Kemp Foundation, and as a member of the Bloomington Planning Commission and the Bipartisan Policy Center Housing Commission. Mr. Brady earned his bachelor's degree in political business from Illinois Wesleyan University. Welcome, sir. Mr. No is the Vice President for Public Policy at the American Forest and Paper Association and is also testifying today on behalf of the American Wood Council. At AF&PA, he works on a wide variety of issues, including environmental regulation, regulatory reform, renewable energy, biomass carbon neutrality, chemicals and product stewardship, and sustainability. Before joining AF&PA, Mr. No had extensive experience in public policy issues, including as Vice President of Regulatory Affairs at the Grocery Manufacturers Association. in private practice and in public service as counselor to the administrator in the Office of Information and Regulatory Affairs, Office of Management and Budget from 2001 to 2006, as well as senior counsel to the U.S. Senate Committee on Governmental Affairs under Chairman Fred Thompson, and we all extend our sincere condolences to the Thompson family. He's truly a great man. Ted Stevens and Bill Roth from 1995 to 2001. Mr. Noel earned his bachelor's degree, Phi Beta Kappa, from Williams College and is a graduate of the Georgetown University Law Center, where he was an Olin Fellow in Law and Economics. Welcome, sir. Our next witness is Mr. Clark. He is a partner at the law firm of Kirkland and Ellis, LLP, and specializes in complex trial and appellate litigation. Mr. Clark has been with the firm since 1996, with the exception of 2001 to 2005, when he was appointed to serve as the Deputy Assistant Attorney General for the Environment and Natural Resources Division of the Justice Department. During his appointment, Mr. Clark supervised the division's appellate section, contained 50 lawyers and staff members, and Indian Resources section with another 25 lawyers and staff. He has argued and won the noted Massachusetts versus EPA case in the D.C. Circuit and is rated, and I quote, AV preeminent, end quote, 5.0 out of 5 by Martindale-Hubbell, the highest level of professional excellence. Prior to joining Kirkland and Ellis, Mr. Clark was a law clerk for Judge Danny J. Boggs of the United States Court of Appeals for the Sixth Circuit. He has written and appeared extensively in public on topics in energy efficiency, clean air and water law, administrative law, and constitutional law. Mr. Clark is an elected member of the Governing Council of the ABA Administrative Law Section and is currently serving as co-chair of the ABA Section of Administrative Law and Regulatory Practices Committee on Environmental and Natural Resources Regulation. Mr. Clark graduated with an AB in Economics and Russian Soviet History, cum laude from Harvard University, an MA in Urban Affairs and Public Policy, summa cum laude from the University of Delaware, and a JD magna cum laude from Georgetown University Law Center. Welcome, sir. Our next witness, Professor Busby, is a professor of law at Georgetown University Law Center. Prior to joining Georgetown, Professor Busby worked at Emory Law School, where he was a professor of law, directed Emory's Environmental and Natural Resources Law Program, founded and oversaw its Turner Environmental Law Clinic, and co-directed Emory's Center on Federalism and Intersystemic Governance. That's a tough one to say, but impressive. He is also a founding member, scholar of the Center for Progressive Reform, a Washington, D.C.-based regulatory think tank. Before becoming a professor, he was a law clerk for Judge Jose A. Cabranes at the United States Court of Appeals for the Second Circuit, an attorney fellow at the Natural Resources Defense Council, and also performed environmental law, land use, and litigation work for the New York City law firm Patterson, Belknap, Webb, and Tyler. Professor Busby has published scholarly works, many of which have appeared in journals, books, news outlets, and blogs. He has assisted with appellate and Supreme Court environmental federalism and regulatory litigation and provided expert testimony before congressional committees on environmental and regulatory matters. Professor Busby graduated magna cum laude with his BA from Amherst College and his JD from Columbia Law School. Welcome, sir. Each of the witnesses' written statements will be entered into the record in its entirety. I ask that each witness summarize his or her testimony in 5 minutes or less, and to help you stay within the time, there is a timing light in front of you. The light will switch from green to yellow, indicating that you have 1 minute to conclude your testimony. When the light turns red, it indicates that your 5 minutes have expired. And what I also do is, you're so intent as I am on wanting to communicate and read and talk to us that no one pays attention to the lights. Even I am guilty of that. So I will diplomatically and politely raise the gavel, just twirl it around a little bit to get your attention, and if you're just so that intent on looking, I'll just give a nice little tap and ask you to please wrap up, if you would kindly do that. Okay, we will begin with Mr. Brady and his opening statement.
There we go. Chairman Moreno, Ranking Member Johnson, and members of the subcommittee, I'm pleased to appear before you today on behalf of the National Association of Home Builders to discuss H.R. 3438 and H.R. 2631, both of which would help repair our broken federal regulatory rulemaking system. As the chairman said, my name is Ed Brady, and I am a small home builder from Bloomington, Illinois. Perhaps it was a simpler time when my father founded our family home building business in 1962, but the complexities of regulation facing our industry today makes it difficult for a small business to survive. Regulations imposed by government at all levels account for 25% of the final price of a new single-family home. Certainly, we need to protect the environment, we need to protect worker safety, but we also need to return some sensibility and sanity to the process. Unfortunately, federal agencies under both Republican and Democratic administrations have increasingly sought to skirt the rules set up by the Administrative Procedures Act and diminish public participation in rulemaking. The bills we will discuss today represent significant progress toward restoring the public participation Congress intended and provided judicial protections when a rule is challenged in court. NHB is particularly concerned about the reliance by federal agencies on guidance rather than going through the formal rulemaking process. That is why we strongly support H.R. 2631, which would ensure that the public has input on significant changes to existing, long-standing interpretive rules. For an example of why this bill is needed, let's look for a moment at the ongoing struggle with the EPA and the Army Corps to define the scope of waters protected under the Clean Water Act. Prior to the regulation that was finalized earlier this year, the most recent Clean Water Act regulation addressing the scope of jurisdiction was finalized in 1986. For 29 years, the EPA and the Corps relied on several interpretive rules, despite two Supreme Court rulings that significantly limited the scope of the Clean Water Act. Those interpretive rules had the same effect and force as a regulation, but never went through the formal rulemaking process. Most troubling is that there is little judicial oversight over the use of guidance. Before we could challenge that this guidance acted as improper rulemaking, we would first have to seek a ruling over the very issue of whether the guidance is, quote, final agency action, unquote, subject to the court scrutiny. The outcome of this would be very uncertain. And while we would prefer that the rulemaking process to work as Congress intended, with public input, a cost-benefit analysis, and an examination of alternative options so the agency gets it right the very first time, sometimes we need to turn to the courts for relief. The second bill before you today, H.R. 3438, provides for a stay of enforcement for high-cost regulations pending judicial review. This is a common-sense approach that would spare small businesses the significant and irretrievable cost of compliance in the event of pending rules overturned. While courts issue preliminary injunctions when a rule faces legal review, these injunctions are unusual and extremely difficult for businesses to obtain. Courts require businesses to show that the regulation would impose irreparable harm, but generally do not include the monetary cost associated with compliance as meeting that standard, even though small businesses have no realistic means of seeking repair from the compliance costs for the rule later thrown out by the courts. For example, the U.S. Department of Labor has recently proposed new overtime regulations, which would make 116,000 construction workers eligible for overtime, according to our analysis. Yet these costs would not likely be considered by the courts as imposing irreparable harm. and even if challenged in court, the rule might still be allowed to go into effect. But if the rule goes into effect, it would immediately alter how small home builders do business. It is simply unfair for businesses to impose the compliance cost of a new regulation while it's under judicial review. The regulatory process is failing us, and we need to repair it. These bills are a good start, and I urge the subcommittee to support them. Thank you again for the opportunity to testify today, and I'd be happy to answer any questions.
Thank you, Mr. Brady. Mr. No?
Thank you. Chairman Marino, Ranking Member Johnson, and members of the subcommittee. My name is Paul Noe, and I want to thank you for the opportunity to be here today on behalf of the American Forest and Paper Association, the American Wood Council, the American Wood Council, and their members on two bills to make important reforms to the federal rulemaking process. We applaud these bills because we believe they are important steps to increase regulatory transparency and fairness, harmonize regulatory requirements, avoid wasting limited resources, and increase regulatory certainty. H.R. 2631 would require public notice and comment when agencies issue an interpretive rule that conflicts with or is inconsistent with the previous long-standing interpretive guidance. This is consistent with the principles of due process, transparency, and accountability that are the foundation of the APA. After the Supreme Court's mortgage bankers decision, it is clear that an agency can reverse the binding policy reflected in a long-standing definitive interpretive rule by simply issuing a contrary interpretive rule. In other words, an agency can change its binding policy from X to not X without having provided the public notice and an opportunity for comment. As a practical matter, by regulating through interpretive guidance rather than legislative rules, an agency often can avoid not only public review, but OMB review, court review, and congressional oversight. That is not good government. As the D.C. Circuit put it, the phenomenon we see in this case is familiar. Congress passes a broadly worded statute. The agency follows with regulations containing broad language, open-ended phrases, ambiguous standards, and the like. Then, as years pass, the agency issues circulars or guidance or memoranda explaining, interpreting, defining, and often expanding the commands in the regulations. Law is made without notice and comment, without public participation, without publication in the Federal Register or the Code of Federal Regulations. Many authorities have gone beyond H.R. 2631 to recommend pre-adoption notice and comment for all significant guidance, including the Administrative Conference of the United States, the U.S. Food and Drug Administration, and the American Bar Association. H.R. 2631 has a more modest scope by proposing pre-adoption notice and comment for interpretive rules, not policy statements, that conflict with or are inconsistent with prior interpretive guidance that have been in effect for a year or more. This bill is a good step toward addressing the problem of regulation by guidance. The other bill, H.R. 3438, would, pending judicial review, postpone the effective date of high-impact rules that may impose an annual cost on the economy of not less than $1 billion. This bill would promote certainty, efficiency, and legal integrity in the regulatory process. All too often, regulations requiring major capital investments are struck down in court, and this is an increasing trend, I believe. H.R. 3438 would avoid wasting resources, stranding assets, and ensure that rules are legally sound before billions of dollars in investment are made. One example of how this rule affects the U.S. forest products industry is EPA's Boiler Act rules. In 2007, about $200 million in compliance investments were stranded in the paper and wood products industry when a court struck down the 2004 Boiler Act rules just 3 months before the compliance deadline. When the rules were reissued in 2013, the new standards had changed significantly, and previous investments proved to be the wrong approaches to achieve compliance. Wasting limited capital undermines the competitiveness of U.S. businesses and impedes growth and job creation. One suggestion I would submit for the subcommittee to consider is to broaden the definition of high-impact rules to ensure that highly consequential rules such as the Boiler Act rules are covered. In conclusion, H.R. 2631 and H.R. 3438 take important steps to promote transparency, certainty, efficiency, and fairness in the regulatory process. We support these efforts, and we would be happy to work with the committee as it advances these proposals through the legislative process. Mr. Chairman, I request permission to include in the record documents referenced in my testimony. I thank you.
Without objection, and I apologize, sir. I believe your name is pronounced Noe.
Yes, sir.
I apologize for that.
Thank you.
Mr. Clark.
There we go. Good morning, Chairman Marino and Ranking Member Johnson and honorable members of the subcommittee. I'm very pleased to be here today, and in addition to coming to help however I can with my testimony, I wanted to note that my wife and oldest daughter are in the room. I thought it would be a good civics lesson, especially with it being voting day in my home state of Virginia. And also, Ranking Member Johnson, my wife lived for a long time, including when we were married 20 years ago in your district in Stone Mountain, Georgia. And she came there after she emigrated from Korea. So with that little introduction out of the way, I can draw a straight line, I think, between my law school experiences in front of Judge Silberman, as I noted in my written testimony, to my career here at DOJ, and to sitting here with you today. And you know, if I were a half generation younger, I'm sure I would have had Professor Busby as one of my professors, so I'm honored to sit alongside of him. Administrative law really is constitutional law. It's suffused with the separation of powers, with due process concerns, and with guaranteeing democratic accountability. And I think both of the bills that you have before you today are excellent bills that would help to accomplish promoting those constitutional ends. The first bill, H.R. 2631, really is the product, I think, of you trying to solve a negative synergy between a number of administrative law doctrines and current provisions in the APA that the paralyzed veterans case enforced. And those rules are 553B, which is what got enforced in mortgage bankers, Seminole Rock deference and its potential for abuse, and Chevron. The combination of those rules really let agencies turn on a dime and defeat reliance interests by individuals and businesses like the NAHB and their members. And by imposing this new requirement that resurrects the paralyzed veterans doctrine, you would help to counteract all of those negative synergies. In addition, I think there are several other advantages which I lay out in my written testimony. I think it advances your power to, as Congress, write the laws. The argument that we often hear from the professoriate that agency processes will be ossified, I think has really become a tired canard at this point. You get to define the nation's policies and legislation, not really the executive branch or the professoriate. Second, I think that these bills, the first bill especially, the one that reverses paralyzed veterans, helps to enhance the separation of powers because it gives time for mistakes to be corrected. It doesn't allow agencies to turn on a dime. It allows agencies that are acting closer in time to the law that was passed that is being interpreted, and so that harmonizes agency action more with congressional will. And third, by giving that time period and making sure that there's notice and comment, you establish that there's an adversary process that can inform judicial review and thereby also enhance the separation of powers through the process of judicial oversight. Of course, the fact that you have notice and comment enhances due process and accountability, and it helps to protect reliance interests. In addition, it protects both public property and private property, not just private property, because many agencies regulate the actions of other executive branch agencies. And and lastly, it's not a perfect solution to the abuses of Seminole Rock deference, but it's kind of a very good second best. It's a very good first start to try to reverse those abuses. And I note that Professor Busby had indicated that perhaps you might be open to seeing that bigger step of reversing Seminole Rock deference. But in the short term, I think this is a good first step toward that. Turning to the second bill, the Review Act of 2015, I started my testimony with the apocrypha from Senator Dirksen of, $1 billion here, $1 billion there, and pretty soon you're talking, real money. I think that providing an automatic legislative stay that will be in place to allow the courts to test the legality of rules, before they actually go into effect when they cross such a monumental threshold is a very good step in the right direction. And I'll tell you, in my experience as a practitioner, that getting stays from the court process are very tough. I tell my clients that there's almost a macro that spits out that just says in a few paragraphs, stay denied. There's not a lot of judicial consideration of those stays. And so providing for an automatic stay in the very limited circumstance where you have a $1 billion rule is a very good step in the right direction. Thank you.
Thank you, Mr. Clark. Professor Busby.
Chairman Marino, Ranking Member Johnson, and members of the subcommittee, thank you for the opportunity to discuss my views of the bills under consideration. And is this working okay?
Yes.
Okay. H.R. 2631, as indicated by the opening statements, would require agencies to engage in notice and comment rulemaking before they could revise long-standing rules, interpretive rules, and I think clearly, as everyone's indicated, this relates to the Supreme Court's Perez decision. And I think, furthermore, the statements of the witnesses indicate clearly this is motivated by concerns with excessive regulatory power, but a few things are neglected. First, most interpretive rules are issued at the behest of businesses seeking consistency and clarity in the law. And I think that this proposal is a bad idea, especially for businesses, and I also think it would predictably backfire, creating incentives for behavior that nobody here would like. Okay, first, there's an important problem with this bill, which is the very definition of interpretive rules. Interpretive rules are not defined in the APA, and there are a wide array of rule-like documents that agencies issue that could be called interpretive rules, but also might not be. If a bill like this is to proceed, we really need to have a clear definition of interpretive rules and what do not count as interpretive rules. Second, interpretive rules address a pervasive problem of legal challenge. There's a lot of work for lawyers because statutes and regulations leave difficult questions, and businesses seek clarity and they seek certainty, and so they ask questions and ask agencies to commit and to give some kind of guidance, and agencies often will do so. However, if you require all long-standing interpretive rules to go through notice and comment, this will not lead to a wave of notice and comment proceedings. Instead, interpretive rules would become rigidified, they would not be changed, and interpretive rules also would cease to be issued, or agencies would be much more likely to shift into more ad hoc modes of policymaking or policymaking through adjudication. This is not desirable. Second, okay, sure, thank you. In addition, the Perez case, which everyone mentioned, actually made a bill like this less necessary. Although the Supreme Court struck down the paralyzed veterans doctrine, it included strong language about the limited legal power of interpretive rules, taking a strain of mostly lower court law and making very clear that these kinds of interpretive rules are not law. They don't have the sort of powerful effect. Similarly, Supreme Court doctrine in recent years has made clear that interpretive rules do not receive the same kind of deference from the courts. Basically, there is not need for this bill, and it would have bad effects that would really have the opposite effects I think people desire here. Let me turn to H.R. 3438, the Review Act of 2015. I think this is a simple bill, and I applaud its elegance, but I think it could have devastating effects on the law and also could cause massive economic, environmental, and health harms, as well as create legal uncertainty. So first, virtually all high-stakes bills are challenged by someone. This bill would stay any bill, any regulation, simply upon the filing of such a challenge. The net effect would be to put regulations in abeyance, usually for years on end, regardless of the merits or seriousness of the challenge. Second, most bills with high-stakes regulations have their own mandatory lead time, or period where people kind of phase in a regulation. An important issue of clarity is how would the tolling or the staying of the effect of a regulation apply to bills and regulations with lead time. Third, rules of broad impact are typically addressing huge risks to the population or the environment. So what are viewed as costs here also are accompanied by costs on people or things that are protected. If a regulation is stayed, those harms will continue during the pendency of any legal challenges. Cost-benefit analysis, many people debate it, but one basic fundamental rule of cost-benefit analysis is you have to consider costs and benefits of regulation. This bill only looks at the cost side of the ledger. Justice Scalia, I know a friend of several members of the panel here, recently said in the Michigan versus EPA case, reasonable regulation requires paying attention to the advantages and disadvantages of agency decisions. Lastly, H.R. 3438 could be seen as an indirect effort to derail bills that could not be attacked directly. If there is a direct, democratically accountable challenge to a statute or regulation based on the merits, then people will know what is at stake. To simply stay a regulation upon a challenge would have an indirect effect and would not enhance democratic accountability. Thank you very much.
Thank you. We will now begin our 5 minutes each of questioning, and I will recognize myself to start the process. Mr. Clark, you suggested that judicial stays are hard to come by, even of high-cost rules, and that they may be getting even harder to come by. Could you provide me with more details about how hard it is and the trend that has been set?
Sure, Your Honor. So, sure, I'm sorry, Chairman Marino. I have an argument tomorrow in the Fifth Circuit, so I'm in Your Honor mode. My apologies. But I would say, yes, in my experience, it's very difficult to get stays. You know, the most regularized jurisprudence in that area is from the D.C. Circuit, and there really is an almost form order that they issue that's just a few paragraphs long. So it's not like, even if you're talking about a rule of earth-shattering cost, benefit implications or the ability to devastate an entire industry, that you're going to get an opinion from the D.C. Circuit about whether a stay will be granted or not. Essentially, all of the balancing of the four equitable factors takes place behind closed doors, and you just get a result of really stay yes or stay no, or if there is a stay, some kind of definition of what exactly is being stayed if it's not the entire rule. And I think that one of the benefits of the bill that you have in front of you to do the automatic stay is that you're showing a value judgment, which I think is entirely appropriate for Congress to make, that if you're talking about a rule that has enormous costs of $1 billion or more, that those should essentially be they wouldn't begin to be implemented until after the judicial review process is closed. I think that's entirely appropriate and would be an improvement over the current system.
Thank you. Mr. Noe, your statement talks about rules for which it would be important to have protections like those in the Review Act. But that doesn't rise quite to the Revenue Act of a $1 billion threshold. What kinds of refinements or alternative tests could be added to the terms already in the bill to make sure that we are covering all the rules that really need this kind of automatic stay protection?
Well, one suggestion I would make, Mr. Chairman, is to focus not on the annual cost, but the total capital cost. As I understand the bill, a large part of the driver here is to avoid sunk capital in complying with a rule that is then determined to be unlawful. And if you key it to total capital cost of not less than $1 billion, you would have captured the Boiler Act rules I referred to. They had a capital cost of over $1.7 billion, but annualized over a 20-year period, as EPA does, they were estimated to be $860 million annually, so it would not have passed that test. One other suggestion I would make is to clarify that the cost includes both direct and indirect cost, because agencies sometimes say, well, it's not this, National Ambient Air Quality Standard that caused the cost, it's implementation of it. And so direct and indirect cost, I think, would be helpful to capture that as well, but I'd be happy to work with your counsel on some specific language.
Good, thank you. Mr. Brady, you alluded in your statement from your experience what regulation has done to the construction business. Could you elaborate on what you've experienced because of the regulation?
A couple things. Thank you, Mr. Chairman. regulation and changes in regulation are uncertainty in small business. Many of you probably have experience in small business, and any uncertainty is very difficult for a small business to perpetuate itself, whether there's jobs on the line or the regulation adds additional costs in the middle of a project or something like that is catastrophic to a small business. As an example, most recently the DOL suggested the overtime, the new overtime rule. I have superintendents, and as I said in my statement, over 100,000 superintendents in our industry would be affected by that. And so I have to go back in my office and say, is it better for me to hire and keep that person on payroll or go into a subcontract position or a contract position? My superintendents have flexibility. They're salaried. They have flexibility on the work day. Many times they work during the weekends to get projects done, but they have flexibility to go take their kids to school or pick their kids up from the doctor or whatever the case may be. And in fact, I think that employee would be hindered by that type of regulation, and certainly my business would be hindered.
Thank you, sir. My time has expired, and I now recognize the gentleman from Georgia, the ranking member, Mr. Johnson.
Thank you, and thank you all gentlemen for being here today, and welcome wife and daughter. H.R. 3438 defines a high-impact rule as any rule that the administrator of the Office of Information and Regulatory Affairs determines may impose an annual cost on the economy of more than $1 billion. This determination requires only a cost assessment and not an assessment of the money saved or the benefits of a rule. Is that not correct, Mr. Clark?
That's correct.
And so is it your opinion that agencies should only consider the cost and ignore the benefits when assessing the value of new regulations, Mr. Clark?
No, Representative Johnson, I think that agencies should do an analysis of both costs and benefits, although the issue of whether they do that or not depends in part first on whether the organic statute permits them to do that or not. But typically, if the organic statute's silent on that issue, then they would need to do an analysis of both costs and benefits.
Well,
here,
HR 3438 would abandon any obligation to look at benefits and just simply impose the responsibility of determining whether or not the cost exceeds $1 billion. And if it does, then the law would require, upon filing of a lawsuit within the 60-day period after adoption, that the rule be stayed.
So in response to that, I think I'd like to make 2 points. First is it's not accurate that it would remove a consideration of benefits. That would remain part of the judicial review process.
Well, not a part of the administrative process in issuing a stay automatically upon filing of a lawsuit.
Right. As a matter of the stay, it would focus only on costs. I would submit to you that I think that's an appropriate thing for Congress to do.
Well, let me ask you this. Let me ask you this. If that law, if H.R. 3438 had been in effect at the time the National Highway Traffic Safety Administration issued the rule requiring airbags in automobiles, then there would have been an automatic stay applied to the adoption of that rule once the auto manufacturers filed a lawsuit, correct?
I don't know exactly what the cost impact of that would have been.
Well, I mean, assuming that it would have had a $1 billion cost.
For the sake of argument, grant that was true. What I was about to say, based on your prior question, was that one of the other constitutional values I think that this automatic stay serves are the kinds of values that go to the vesting clause, the fact that you are the lawmakers and not the agency.
Well,
And so
certainly.
all that this does is reinforce essentially kind of non-delegation
Well,
values.
what this does is puts adoption of a rule into the purview of whatever the opposing party of the rule decides whether or not to file a lawsuit or not. I mean, it would just automatically stay adoption of the rule. Now, Professor Busby, what is your assessment of what we have just heard from Mr. Clark?
Well, I agree with your view that that a regulation needs to be assessed for both the cost and the benefits, and having an asymmetrical examination only of cost with an automatic stay basically doesn't follow the basic sound views about cost-benefit analysis.
And that's exactly what H.R. 3438 does it not?
Yes, it does.
And with respect to H.R. 2631, isn't it a fact, Professor Busby, that parties are not bound by the interpretation of agency rule? There's no binding legal effect on parties. Isn't that correct?
That is correct.
With that, I'll yield back.
Thank you. The chair recognizes the gentleman from California, Congressman Tyson.
Thank you.
Mr. Chairman, if I might.
This moment.
Mr. Chairman, if I might, I do have some statements for the record. One
Yes.
is Ranking Member Conya's statement, his opening statement. Also, a statement from William Funk Lewis and Clark Law School. Also, a statement from NAACP calling on EPA to set a strong final ozone standard, highlighting disparities in health impacts from air pollution. And also a letter from 40 health, labor, faith-based environmental justice, and frontline community organizations calling on EPA to set a strong final ozone standard. Also a letter from 16 public health and medical organizations opposing any attempts to block, weaken, or delay Clean Air Act protections. And last but not least, an article in The Hill entitled Arguing About the Cost of Regulation but Ignoring the Benefits by Stuart Shapiro. I would ask that these be placed into the record by unanimous consent.
Without objection. Now, Mr. Issa.
Thank you. That was well worthwhile. Following on Ranking Member Johnson's line of questioning, I think it was a good line of questioning, but I'd like to take it in a slightly different way. And I'll go down with a question for everyone. Mr. Busby, do you think that there's anything wrong today with the current situation in which a $1 billion or greater cost to the private sector can be passed on by an agency years, even decades, after the passage of a law by Congress, and in fact you must effectively do it or be in peril until or unless you prevail in court, perhaps 4 or 5 years later? Just a yes or no. Do you think that status quo today is okay?
Well, I think the supposition that there isn't an opportunity for a stay before the courts is not correct.
No, well, you have to go to the court and get a stay.
That's correct.
Very few agencies think that their new rules are frivolous enough for them to grant the stay. So by definition, you have to go to the court, which means you have a period of time and a high standard. You just yes or no, do you think that's a good standard today?
Well, I think many agencies actually add lead time.
Professor, I want to know if you think the current standard, not what benevolent government bureaucrats do. You know, I'm not from the side of the aisle that believes in benevolent government bureaucrats. So excluding all the good things that sometimes happen, do you think the current balance of what can happen is okay? Yes or no, please.
I believe the administrative law doctrine is quite sound in this area.
Thank you. Mr. Clark, I would go down and just say, how would you answer that yes or no question?
I think, Representative Issa, that's an intolerable status quo. And if I could just supplement a little bit to the answer I wanted to give to Representative Johnson.
You can in a second. Let me just get down this, and then I'll get back to you.
Congressman, I think the status quo is very problematic and flawed.
Mr. Brady, living under these laws, I assume your answer is you don't think the status quo is particularly good.
No, the status quo is not good for small.
Okay, so 75% of the audience here today says that they want to rebalance this. Now, the Act moves the burden, if in a sense, the other direction, doesn't it, in the case of multi-billion? And agencies, including ones that my former committee next door looked at, often underestimate. So a multi-billion-dollar one affecting dust for farmers and so on can sometimes be guessed at a very low level and thus circumvent the $1 billion responsibility. Mr. Clark, you're familiar with some of those cases where they guess low.
Yes, or the cost-benefit analysis, in my view, sometimes is often deliberately skewed.
So as we look at this legislation, I'm going to ask you a series of one question. I'm going to get back to Mr. Clark, give you that opportunity to follow up. But as we look at the rebalancing, isn't the obligation of this committee recognizing we're only dealing with regulations that come out that essentially are adding to a law that is more than a year old, a new regulation in which they did not do it in the original passage of law. And I think it's important that that limitation, we're not dealing with the act of Congress and then the rulemaking afterwards. We're dealing with second-guessing and new thoughts on legislation that could be decades old. Should we consider, for smaller than $1 billion, still having an expedited ability to get to the court for that decision? And if so, should we consider that the court, instead of having the burden be irreparable harm, have a simple balance of cost and benefit? And I ask that for a reason, because if it's $100 million and on balance it costs more than it saves, it may not be irreparable harm, but as was said by the chairman in the opening statement, currently just having it cost you a lot of money and doing very little benefit doesn't happen to be a standard that the court would consider. So as much as I like the billion, I like the shifting, my question to you, and I'll start with Mr. Clark, is should we consider a balance that puts the court in an expeditious fashion in a position to evaluate sooner and on an expeditious basis, even if it's below $1 billion? Mr. Clark.
I think expedition would be helpful, although I would say that since a lot of these rules go to the D.C. Circuit, it's not as if their caseload is particularly high. And then I'd also say that...
I don't know. They're still working on Fast and Furious from 2010.
True enough.
You know.
I like the idea, Congressman, and I'm happy to welcome Professor Busby to the regulatory reform movement. It sounds like he likes cost-benefit analysis, and I would encourage Congress to require that by statute.
As do I. Mr. Brady, you have to live under these laws. How do you, regulations that agencies come up with years after laws are passed, how do you feel about that?
Well, you're exactly right. And the one case that I quoted earlier is the Department of Labor on the overtime. They scored it at a $200 million impact cost. That was direct administrative cost. They didn't take into effect the cost that an employer pays the employee, which is well over $1 billion. So yes, we would support, this is a great first step, but we would support looking at that cost-benefit analysis even under $1 billion.
Mr. Chairman, I think Mr. Busby wanted to weigh in, and I don't want to cut him off unfairly, but thank you, Mr. Chairman.
Go ahead, Mr. Busby.
No.
No?
Thank you.
All right, the chair now recognizes the gentleman from New York, Congressman Jeffries.
Thank you, Mr. Chairman, and I want to thank the witnesses for their presence here today, their testimony. Let me just start with Mr. Busby. Am I correct that most interpretive rules are promulgated most often at the request of the industry?
Yes, that is correct.
And these requests are generally made to address regulatory uncertainties. Is that correct?
That's correct. It's both to address regulatory uncertainty, and then agencies also usually desire to have consistency in implementation and enforcement, and hence both business and agencies see benefits to clarity in their interpretive rules.
So what would the risk be, if any, if we were to move forward and subject revisions to the interpretive rules related to notice and comment rulemaking?
I think the most predictable effect is the backfiring I talked about. If you add process, impose new process on agencies, examination of past similar proposals is that agencies will avoid that additional process. So instead of having lots more notice and comment rulemaking, you probably have fewer of these clarifying interpretive rules and more policy making through adjudications and more ad hoc conversations.
And what, if any, benefits are there as it relates to interpretive rules for both agencies, but more significantly the industries that they regulate?
In my experience, both as professor and then also when I was advising industry, is there's great difficulty in figuring out the answer to particular questions. So typically businesses seek more guidance, not less, and they really would like to have agencies say what they wanted. I was at a proceeding years ago, and a home builder said, I don't care what the rules are, I want to know what the rules are, and if I can know what the rules are, then I can comply. And interpretive rules tend to bring that sort of clarity, and that's the idea behind them.
Now, Mr. Brady, you mentioned that I think uncertainty is catastrophic to a small business. Is that correct?
Yes.
And would you say that there's uncertainty as it relates to the period of time in early 2013 as to whether we were going to fall over the fiscal cliff or not? Was that uncertainty that was?
There was a lot of uncertainty.
And would you say there was uncertainty as it relates to the impact of the sequestration cuts that have been imposed upon this country as a result of a deal that was struck several years ago that creates a climate that could be adverse to small businesses in America?
In regards to the sequester?
Yes.
Potentially, yes.
When the government shut down in October of 2013, which I believe it was 16 days, it cost the economy about $24 billion in lost economic productivity. Was there uncertainty as to the chaos that was imposed upon us as a result of this addiction with the Affordable Care Act repeal? Was that uncertainty problematic in terms of the government shutdown?
Yes.
And we've been engaged in this process of serial flirtation with defaulting on our debt, which would be the first time that we would default in our nation's history were that to happen. Even though we're charged constitutionally with protecting the full faith and credit of America, does the serial flirtation with not raising the debt ceiling and defaulting on our debt, aside from the catastrophic economic consequences that would be caused, does that create a level of uncertainty that's problematic for small businesses across America?
Well, you're a little over my pay grade on the debt on the debt limit, but I must.
I think that's the easiest question of all.
But I must answer the interpretive. There's uncertainty in interpretive rules, and for 29 years we worked under interpretive rules. Those interpretations can change from administration to administration, and that's the uncertainty with an interpretive rule that hasn't gone through the rulemaking process. There's uncertainty.
Now, Professor Busby, you mentioned that H.R. 3438 would cause legal uncertainty. Can you just elaborate on that dynamic and why that would be problematic for the industries that are seeking relief from regulation?
Well, one important aspect is by not defining what counts as costs. If this became law, there's a lot of different ways you can define costs. Some people call for cost-effective regulation. Virtually everyone says that if you're going to do cost-benefit analysis, you don't just look at direct effects, you look at all of societal costs and benefits. As Mr. Noe years ago worked on the idea that you should look at all societal costs and benefits and then look at the net of them to figure out if regulation is a good idea. This bill, by saying you'd stay any regulation by just looking at costs, might stay a regulation that might be incredibly important and leave people very vulnerable.
Thank you, Mr. Chairman. I yield back.
Thank you. The chair now recognizes the gentleman from Michigan, Congressman Bishop.
Thank you, Mr. Chairman, and thank you to the panel for being here today, and appreciate your testimony. I'd like to begin, if I could, with Mr. Clark. Critics of the Review Act say that it will stop urgent rules in their tracks. Professor Busby indicated that added process might discourage rulemakers also. But in your written testimony, I thought you provided the perfect answer for that statement when you indicated that if a legislative rule, if a rule was that important, that Congress should take the initiative and pass a statute as provided in our constitutional duty. I just want you, if you wouldn't mind, to expound upon that. And doesn't your answer highlight how upside down our modern concept of how to legislate and how the process works? And it seems to me that, of course, I'm new here, so I'm learning as I go, but as I sit through these hearings, I note that the power of Congress has slowly been handed over to unaccountable bodies. And we in Congress have very little authority to step in. And I listened to the questioning earlier from my colleague across the aisle who suggested that all of these other uncertainties, when he's talking to Mr. Brady out there, that were caused by Congress. Certainly they are uncertainties, but at the same time, Congress is accountable. Ultimately, we have to face the people that that sent us here. Agencies don't have that same accountability. So I'd like you to talk a little bit about that answer, and if you wouldn't mind, just expound upon your thought on the current state of our system.
Yes, thank you, Representative Bishop. I agree with all of those remarks, and I think precisely true. If you're talking about a monumental regulation that would impose, more than $1 billion of costs, to essentially, say if that truly is seen as something that's urgent, you must have whatever the health and safety benefits or other benefits of the rule are, that the easy answer to any objection like that is for Congress to pass that law. That is clearly more legitimate under our constitutional system than to have it be done via delegated power. And this allows me, I think, to provide the rest of the answer to Representative Johnson, which is it's not unfair to have an asymmetric consideration of cost here, because all you're doing, as Representative Issa recognized, is flipping the burden of proof, and I think you're flipping the burden of proof to be more in a constitutional direction. If a rule will impose more than $1 billion of costs, make the regulators, don't presume that they're correct in their cost-benefit analysis, make them prove that the benefits exceed the cost through the judicial process, and don't let a rule like that go into effect until the judiciary has agreed as an independent check on that delegated power with the agency imposing a rule of that magnitude.
Thank you very much. I'd like, if I could, also to turn to Mr. Brady, and I want to thank you for being here and thank you for representing small business, because I know that small business is really the most impacted by this increase in regulation and this regulatory environment. In your testimony, you stated that for 29 years the EPA used various interpretive rules in lieu of going through the rulemaking process for the Clean Water Act, and we hear in our districts all about that process, especially with regard to the Clean Water Act. And I'm wondering if, after all this, did that period offer any clarity or certainty in your industry?
The interpretive rules?
Yes.
Well, it produces clarity at the moment. What it doesn't produce, or what it also produces, uncertainty as to where it's moving. I mean, the Supreme Court issued two rulings on interpretive rules of the Clean Water Act, and yet those interpretive rules were not substantially changed according to the Supreme Court's rules. And there was no public hearing, no requirement to create or give input from the public as the APA is supposed to do. And so those regulations, interpretive, do not necessarily create the clarity long-term that a business needs. I will also say that one shoe doesn't fit all. And as somebody suggested earlier, interpretive rules are based on industry asking questions for clarity. And that may be clarity to a large business, but not a small business.
Thank you, sir, and I yield back.
Thank you. The chair now recognizes the gentleman from California, Congressman Peters.
Thank you, Mr. Chairman. My colleagues know that I practiced law in this field before I got into government, and so I'm pretty sympathetic to some of the stuff that you're talking about. And Mr. Brady, I want to ask you a couple questions, just to make sure I understand what the objection is. You gave an example about overtime rules that might take effect for a business who's maybe already into a project. And so I understand if the problem is the law or the courts. and you couldn't recover those, obviously, if you were forced to pay these wages because a new rule came into effect, you were able to sue, overturn the rule, you'd still be out that money. Would that not be irreparable harm under the law, and you're just not getting an injunction from the court?
I think that it would be irreparable harm, but that's a very tough thing to prove and a very tough thing for a small business to get a stay based on that.
Right. I'm thinking that maybe the objection is more that the courts are not doing their jobs under the current standard by recognize this is irreparable harm. This is money I can't get back. It might be a lot of money to this in this micro level. Forget about the $1 billion. It's irreparable harm to that business. And I would say that I would agree with that, but the problem is maybe that the courts aren't observing that.
Well, from the law perspective, I don't mean to speak from an expert position, but again, the courts, you're right, the courts have not been willing to issue those stays when we argue irreparable harm.
Okay. The other thing is you talked about the idea of a law coming into effect while a project was going on. Has there ever been an attempt to grandfather projects that are, say, permitted or under construction so that they're not subject to new regulations? And is that something that you think would be constructive?
It could be constructive, but this law, the overtime law, is indexed every year per the law. So that means that we have to change those. We don't know what that index is until January 1st.
So in this particular case, that wouldn't be applicable. But I guess the question you raised in my mind was whether you're doing a project and all of a sudden the law changes. Maybe the project would be protected from that through the duration of the permitting.
On a long-term project, that may be able to be
that's
done,
not the issue.
But from a short-term perspective, there's still that uncertainty as to what you're dealing with, and whether or not that person is an employee still versus a contract person.
Mr. Noe, I wanted to give you a chance to respond to Professor Busby. So, with respect to these letters that you get from an agency, it was often my experience that you desperately wanted the agency to tell you what they meant by this, how they were going to treat it, so that you could count on it. And I understand the frustration you state of, you've been relying on a particular interpretation for many years, all of a sudden the agency changes it, and that's got to stink. I get that. But on the other side, how do you deal with the fact that you might further bureaucratize this process by telling them that if you do give us an answer to this question, we might sue you? And the thing we talk a lot about here is empowering people to make decisions. And it seems to me, so I'd just like you to sort of respond to the professor about how that would be consistent.
Thank you for that question, Congressman. And I would say that of the witnesses here who work in the business community, we all support these bills. And the reason is, yes, we want clarity. Yes, we do ask agencies for interpretations. But we also want due process. And I think that's what the bill would provide. That we also find it very hard to operate in a regulatory system where there's actually now an incentive, and agencies are going in this direction to hollow out their legislative rules. A lot of the controversial issues are not in those rules. They pass through OMB review. You don't have an objection here because what's there to object to? And then along comes an interpretive rule without due process, without notice and comment, and then they can do a 180 and say one day our policy was X, and the next day it's not X. I can give you a specific example where you can imagine an agency issuing a broadly worded legislative rule with a preamble that says what we mean is X. They could come out under mortgage bankers later with a letter or something that says not X.
I actually think I agree on the phenomena, and I actually have a lot of examples that I get steamed about where the government gets away from what Congress intended. The government actually is fighting with its own citizens, with its own businesses. It drives me crazy. I just want to, I have 14 seconds left, so I'm not going to be able to talk about it now, but I'd like to talk to you more about how to preserve the flexibility to answer a small business's question about what the heck am I supposed to do, because that's often how it comes up, without doing this thing that you described, which is to really to be unfair and to be inconsistent with the law, which is something that deserves a remedy. I just don't think we've landed the plane on that yet. I'd like to talk about it more. Mr. Chairman, my time has expired.
Chair now recognizes the gentleman from Georgia, Mr. Congressman Collins.
Thank you, Mr. Chairman. Again, this is, and I go back to both Mr. Bishop and also Mr. Peters in his question. I think this is the problem that most people are just struggling. Mr. Brady, that's why in a panel like this, I appreciate, you being here and actually having the what I call the boots on the ground. You have to live with this all the time. I've had in my office just recently, it's not just a matter of also the interpretive language, it's also a matter of getting actual agencies, if they're going to do a rule, to actually do the rule. And I've got businesses right now that are having to make multi-million-dollar decisions based on the salt or lack of salt in processed foods that are going to school lunch programs. They're having to make the decision now because actually business understands that you actually have to plant your crop before you get a harvest. Government doesn't understand that. Government, if you worked in the little cubicles down here, which God love them, they're great folks. They need to be smaller in size, but they work down here for the good of folks. That's not the way it happens. They just can go on, and because they're never held accountable to any end standard. They're accountable to a piece of paper that's brought out at the end of the day. Mr. Busby, you said something that is really interesting to me. How in the world, and again, you have to understand, if you've heard me on the floor and you've heard me here, I am not at all concerned about imposing a little bit of work on an agency. That is not a problem, okay? My problem is when you said that to impose due process or substance actually would be a problem because then they would begin to skirt. I want you to explain a little bit more on what you were saying there.
Sure.
Because that right there is just terrible.
Sure. I'd be happy to. Supreme Court doctrine going back actually to the 1940s and 50s has made clear agencies can make policy in several different modes, and the Administrative Procedure Act has also long recognized that. And so when you add a regulatory burden on one of the options, here interpretive rules, agencies will look at the other options they have, and one of the options agencies have is to do things on a more ad hoc basis, or possibly through other forms of non-notice and comment rules. And so what may end up happening is more ad hoc and less known law, and that's been long established that agencies have that choice. The law doesn't force them to do notice and comment rulemaking, even if people think that would be a good idea in some areas. Some statutes do. Some statutes say regulations in a particular area have to go through notice and comment rulemaking, and often with deadlines, and then agencies do them. But usually interpretive rules are 2 or 3 layers down below a high-stakes promulgated regulation. Just one example that there was mentioning of the Waters of the United States rule in Rapanos. The Supreme Court came with an extremely confusing decision. The Army Corps of Engineers and the EPA immediately, or within a few months, tried to come out with a guidance document interpreting that ruling so people would understand how they understood an extraordinarily confusing decision. And not everyone would have necessarily agreed with all aspects of it, but it brought greater clarity to the law.
But I think what we're looking at here, and then Mr. Brady actually brought that, even though you had a Supreme Court ruling that did sort of lay it out, and frankly, there were many people who understood what the Supreme Court was doing. I mean, we can lawyer everything, I can lawyer everything to death, and you can as well. That's why there's a lot of problems in this. The problem is interpretive rules have they quote formally through court cases lack the full force and effect of the law. But from a builder perspective, how many times have you had a building inspector come to a home you're building and give you a interpretive ruling on how high a fence was to be or how much, and who's the law at that point?
Well, they're usually the law because they won't give me the sticker unless I interpret it the same way that they do.
This is the problem we're getting at, and I'm not sure, and anybody would like to take this on, is when we're looking at these, there could be some issues, and Mr. Clark, I think you had brought up an issue of actually doing it below $1 billion. Real quickly, is there a place where you would draw the line on, Mr. Noe, the one that we used, you broaden the applicability of the Review Act to below $1 billion. Is there a line below $1 billion? Or like a number? Do you have a number in mind? Is Mr. Clark, Mr. Noe?
Go ahead.
I would recommend, I respect if the committee wants to have it only apply to the very small handful of rules it applies to now, but I would hope at least it's clear that it's total capital cost, whatever the number is. I think, frankly, there are a number of rules, though, that could affect small business or other entities that wouldn't hit that threshold, and so it's for you to consider whether you'd want to lower that further.
You don't have a number in mind, Mr. Clark, do you?
Yeah, I would say that, just as a quick, thing, suppose you considered it to be half, $500 million on a threshold that ties to small business where that, an impact of that magnitude could be catastrophic for small businesses so that you have sort of one speed for large businesses and one speed for small businesses.
Well, I think the biggest thing here, and I've tried to get something from all of you in this as I'm closing up here, simply is these interpretive rules, whether it's before the billion cap, non-billion cap, we're dealing with issues of real-world significance. There is a cost-benefit analysis. There is something that to say that you do need this $1 billion and decide if we're going to have a suit or not, because otherwise you can stop things. And for the interpretive reason, this says we need to take a look back, and I don't see anything wrong with an agency of any kind doing a comment open period so that we can get some of this clarified. And this is a good reason for this hearing. Mr. Chairman, I yield back.
Okay, the chair now recognizes the gentleman from Texas, Congressman Radcliffe.
Thank you, Chairman Marino. Gentlemen, thank you all for being here today. The industries that you represent are essential to manufacturing in this country, both with respect to job creation and economic growth, and they're certainly vital to the families in the 4th Congressional District of Texas, which I'm honored to represent. So from my perspective, this hearing couldn't be more timely or more critical. And frankly, in hearings like this, I'm at a loss when I hear my colleagues on the other side of the aisle express concern about reforms that would force regulatory agencies to be more deliberative and more thoughtful, as if that's troubling or a bad thing. And I couldn't agree with you more, Mr. Clark, when you said that this is really a separation of powers issue. And I would certainly hope that folks on both sides of the aisle would agree that we'd be better off in this country if we were solving the problems that need solving in our communities, not by regulations legislated by unelected bureaucrats at unaccountable agencies, but instead by statutes legislated by an accountable Congress. Let me turn to you, Mr. Noe, because the impact of your members, those in the paper and the wood products manufacturing industry, is a big economic driver in the 4th Congressional District of Texas. I want to make sure that those businesses and the families that they represent aren't crushed by regulations that require not just millions, but in some cases billions of dollars in compliance costs. And in your testimony, you talked about sustainability efforts that the paper and wood products manufacturing industry has had to take in recent years, and you talked about costly regulations from the federal government, an additional $10 billion in new capital obligations that you expect will come in the coming years, and that is a regulatory burden that you called unsustainable. With that in mind, do you think that the Review Act that we're considering, H.R. 3438, would actually incentivize agencies to work with stakeholders in the paper and wood manufacturing industry before issuing regulations, thereby resulting in more legally sound rules and, in fact, significantly reducing regulation that we'd have in this country?
I absolutely do, Congressman, and I think you make a great point. I think what's being lost in the discussion about you should consider benefits as well as costs is that we're talking about regulations that are later declared to be unlawful, okay? And that creates tremendous waste of limited resources, which affects ability to hire, capital expansion. In other countries, to your point, my understanding, and I'm not an expert in foreign regulation, but there's much more of a accommodation, the regulators working with the industry on capital planning for highly costly rules. We have a very adversarial legal system where that doesn't happen as much as it should. And when that does happen, mistakes can be avoided. The airbags rule that Ranking Member Johnson referred to, for example, NHTSA actually originally made a mistake in those rules. They didn't consider the risk from high-force airbags, and there were a number of fatalities because of that. I'm not saying, I don't know enough about that to say the Review Act would have avoided that, but I know it would avoid mistakes that are made. And so we're talking about a bill that could lead to sustainable regulation, increase the legal soundness of it, and really avoid mistakes, and that's where you're going to get real benefits. If I could, I just want to show you from a distance. This is a picture of the clean air regulations, just one program of one agency that our industry faces in the next 10 years. This is what people face when they run companies in this country, and it's a scary picture.
Thank you, Mr. Noe. Mr. Brady, your industry, the home builders, is important in my district and every district, I would hope, in this country. I want to give you an opportunity to expound on Mr. Noe's comments and answer the same question.
Well, when I suggest that 25% of the cost of a home is regulatory. It can tell you the burden that the regulatory environment puts on the cost of a product, which is an affordable housing issue, being able to produce product at an affordable price. It affects the amount of people that I can put on the payroll, the amount of houses that I build and employ people to build those. The regulatory burden, and as I said in my statement, we need to protect workers, we need to protect the environment, but the regulatory burden on our industry alone is cutting affordability, it's cutting job creation. We had 240 members of our association 6-7 years ago. We have 140,000 now because many of those businesses are out of, they're not around anymore, in part because of the regulatory burden that they have to live by.
Well, thank you, gentlemen. I wish I had more time to expound and highlight on these issues today, but I see my time's expired, so with that, I'll yield back, Mr. Chairman.
Thank you. Seeing no other members present, this concludes today's hearing. I want to thank the witnesses for being here. It was very enlightening. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. This hearing is adjourned.
Nice to see you.